Thank you very much. Hello, everybody. It's a pleasure to be here. I look for any opportunity I can to talk about my program. I can tell you that the biggest issue that we have here in the office is that the re-victimization. So many times we run into a victim or we hear from them, even from law enforcement or a prosecutor's office, that they were told that we could do something for them, that we can provide a service for them that we just simply cannot provide. So any opportunity we get to get out and to spread the word about what our program can and cannot do for individuals who are victims of crime, we look forward to those opportunities. With that said, my name is Nolan Jenkins. I am the director of the program, the Victims Compensation Program here at ICJI. So on behalf of ICJI, thank you for this opportunity. If I am still sharing my screen and my wonderful supervisor I have on staff, Alicia Sanders, has got me set up now, I will get right into it. Now we can go as quickly as you like, or I can answer any questions you might have. Because again, I look forward to these opportunities. Anything that I can clear up for you during this presentation, I'll be happy to do so. Because ultimately, that helps our victims, and that's what we all want to do. Just a little bit about the Victims Compensation Unit. As you can see, we've been in existence actually since about 1978. We were created by the State House. Victims Comp awards were being passed out about that time, and so all the states were scrambling to receive the funds. Some victims compensation units are housed within Attorney General's offices around the country. Here in Indiana, they decided to set up a standalone agency. There's other grant opportunities, victim services and traffic safety and other things that come together to form the Indiana Criminal Justice Institute. But I am going to talk to you about victims' compensation. It is our mission to try to provide for the claimants or dependents or the victims of crime. We try to provide for that unexpected financial burden of being a victim of a crime. So we have funds. I'll get into the specifics here in just a moment. But we exist to try to help the people of Indiana. Now, if the crime occurs in Indiana and our victim is just traveling through or here on vacation, then we can still help them. We can still help them. Okay. This is a list of my staff using an older presentation. So the list is not exactly current, but it's just the point of the slide is that you can reach out to either myself, Alicia Sanders there is my working leader or my supervisor on staff. And then we have three other employees that will be glad to answer any questions you may have. And they take questions directly from victims all day long, and our hours are 8 to 4:30. And you can see, and I can share a copy of this presentation, but you can see the 800 number there at the bottom. We strongly encourage all of you, if there's a question that you just simply cannot answer or you're not sure about, either you or the victim or claimant can call us directly and we'll be glad to answer their questions for them. But basically, we have two applications, two funding streams that we accept here in Victims Comp. Two applications. The violent crime application, I use federal funds through the VOCA grant that we get every year. That VOCA is Victims of Crime Act. We get that grant from the Department of Justice every year. I use state funds for our sexual assault program, which I'll talk about secondly. And that is for our sexual assault victims. If the sexual assault occurs in Indiana, they receive a forensic exam. All the providers know to send my office those bills. But we will talk about the Violent Crime Compensation Fund first. So who can apply? This is a common question that we get, but this is one of the more common questions that we get is who can apply. Say, for example, we have an individual who passes away and he has two children by two different mothers. If he was not married to either one, then we cannot accept an application from either one. It would have to be a legal spouse, parent, grandparent, adult sibling, 18 or over, or an adult child of the victim. And this is largely because of the application has to be signed by someone who can give us the authority to do our investigation. The applications are on our website. They are printable. Right now, we're having some difficulties with the website. The paper applications, though, are still there. It's just unfortunately right now, the victims cannot apply online. So they will have to go to our website and print off an application, or you as advocates can go and print off applications and keep them in your offices if you like. For right now, that is the only way we can get the application is through the mail. Now they can fill them out. You can fill them out on their behalf, and we can take them through our fax machine. It's just hopefully, or we have a fax number. Hopefully we just need a clean copy that is legible to us and we can read it. So right now our online portal is down. We are in the process of purchasing a new claims management system. Unfortunately, we're about 7, 8 months. It'll be about 7, 8 months down the road, but that will open back up to the public and it will do a lot more. It'll be a lot more interactive for our victims and claimants. Looking forward to that. The applications themselves, as I said, they must have the proper signature on it before we can accept it. And usually my staff will work with those individuals in the case of someone who wants to apply because they have a child by our victim. It depends on what they are applying for. Common misconception, if you will, is that we are going to send $1,000 max to whoever gets us the application first. That is simply not how our program works. And so what my staff is trained to do is to reach out to the child's mother or father in some cases and find out exactly what benefit they were looking for and try to meet their needs that way. Unfortunately, typically it's reimbursement for the funeral. And again, once we get to that point, we will reimburse whoever paid for the funeral. We just need the application from somebody who can legally give us permission to do our investigation. Once I receive that application in our office, either me or my supervisor on staff, Alicia, will get that assigned to an analyst here. And then a letter will go out to them, either letting the claimant or victim know that we received their application and it was complete, and give them the name of the analyst assigned to their claim and all of their analyst contact information, or it will tell them that the application was incomplete and let them know what information was missing. This is a copy, just a quick copy of our 2-page application. All the information is important, and we always stress that. We get a lot of victims or claimants who will fill it out and put NA for non-applicable in several different locations, and usually that just slows up our processing, especially when it comes to the police information. Kind of at the bottom there, at the first page that's on your left, we need to know where to send our request for information to. A lot of times when a crime or incident occurs on the side of a road, our applicant is not sure if it was a local police officer, state police, county sheriff who answered the call. It's just very important for us to get the right information, because what happens is we'll send a request for information to the wrong agency, and that just delays processing. So it is very important. And then any contact information for that officer that they can give us just speeds up the processing of their application. If they have the detective's name, they can include that. And when we send our request, that request can go directly to that officer instead of mailing a request in general to their address. It's always better if we have a name to put on our request. Okay. The other thing I will point out with this application, I've already talked about the signatures, but if you look at the second page on the right, those 3 boxes that are up in the upper left-hand corner of the second page, if those 3 boxes are not initialed, that will determine that this application is incomplete, and we have to get a complete application from the applicant before we can continue processing. So if you take a look at it, the first box that they're initialing, and they're just simply initialing these boxes and acknowledging that they have read and understand, it's not really asking them for permission. So we want them to understand first that there's a release of liability. In no way, of course, is the state of Indiana responsible for paying their bills. It's an application process. We will review the application. We will do our investigation, but at no time is the state assuming responsibility for their bills. or any liability for their bills. The subrogation clause is if there is a civil suit filed against the offender, and this does include restitution ordered by the court, which we'll talk about more in a moment. We need the applicant to understand that our fund is to be reimbursed. But this is only if money is paid out. If we get a copy of a restitution order, but the offender has not paid anything towards the restitution, it was just ordered, we will not hold that against the victim, and we will still pay out the claim, whatever is needed, whatever they are eligible for. We just need them to initial that box. The third box, we just need them to understand that we are required to pay the providers first. As all that box is indicating. Now, in some cases, we can't pay the provider. A lot of times this happens if there is a crime close to the border. In Indiana, say a crime occurs in Jeffersonville, Indiana, and the victim goes across the bridge into Louisville, Kentucky, and receives medical treatment. Most of the providers in Kentucky do not want to participate in the Indiana program. And when that happens, if there's no other way to get that provider the money, we will give it to the victim and we consider the bill paid in full. The crime must be a felony or a Class A misdemeanor resulting in bodily injury. I always try to highlight a very common question that comes up every week in our office is when a vehicle is involved. That vehicle, the driver of the vehicle must be charged with driving under the influence of drugs or alcohol for it to rise to the level of a crime. The only other instance where application from a vehicle incident can be accepted is if we receive information from law enforcement that the vehicle was used intentionally as a weapon to hit someone. Once we get that information from law enforcement, we can continue to process the claim. But other than that, must be a felony or a Class A misdemeanor resulting in bodily injury. The crime must occur in Indiana. And as I said previously, if someone is visiting Indiana and they're injured as a result of a violent crime, they can apply to our office. I will point out that every state in the country, including our territories in the Virgin Islands, Puerto Rico, and I believe last couple years, Guam has gotten a victims comp grant. You would have to apply in the state or territory where the crime occurred. At that point, if you go to another state, or for example, if it's in another country, that country would have to offer a victims compensation program. I can tell you right now, Mexico, for example, does not. So many that we do receive applications regularly, unfortunately, from domestic violence issues that occur while a family is on vacation. If it occurs in Mexico, that applicant came home, the last one I can think of, she came home to Hamilton County, received medical treatment in Hamilton County. We were able to accept her application and reimburse her for the medical costs. The crime was reported to hotel security, and we were able to accept that as reporting to law enforcement, and we were able to help her. And the crime does need to be reported within 72 hours. And according to our statutes, the victim must be cooperating with law enforcement. They must be willing to participate in the prosecution of the offender. Now, if no one is arrested, it's fine. All they need to do is check the box saying they are willing to assist with prosecution if someone is arrested. And now, in our statutes, some will read our statutes, and it does say that the victims or the victim's family have 180 days to get us the application. But it goes on to read if basically they have 2 years. It says with just cause. We used to require an explanation as to why we didn't get the application within 180 days. And typically all we were getting was, we didn't know about your program. We don't even ask for that letter anymore. We just give everybody 2 years. But unfortunately, if it's 2 years and 1 day past the date of the crime, I cannot accept the application. As I said, they must be willing to cooperate with law enforcement. Now, there's a couple things in our statutes that we can't get around. One of them is that our victim must sustain injuries and have more than $100 out of pocket medical expenses. One thing I can tell you, though, is even if those expenses have been paid by the victim's private insurance, Medicaid, Medicare, they just need to submit us the bill so that we can see to satisfy this requirement, even if it's paid in full by their insurance. They still need to submit the bill to us. Legal dependents who witness a crime, and this is for minors, if they witness the crime and we receive that information from law enforcement, they are eligible for counseling. It's a little tricky. There are times when, obviously, we would love to offer counseling to everyone who is affected by crime. Unfortunately, we just simply can't. Our program was not set up to do so, but there was a change made a few years ago. And if a minor child is in the room or they've actually witnessed the crime that occurs, they witness a domestic violence issue, we are able to offer that minor child counseling now. And with this one, when it comes to sexual assaults, they can be filed as a violent crime. But if someone is the victim of a sexual assault and they go into a medical facility and they receive a forensic exam, by law, that hospital or whoever provides the forensic exam is prevented from charging them for that exam. The application and those bills will come to us. But that is to cover the charges directly related to the forensic exam, the gathering of evidence. If the victim's injuries are more severe, or if the victim has to be hospitalized because of their injuries, I can accept a violent crime application from that victim for the same incident. That will allow me to apply the state funds towards their forensic exam, but then that will also give me the violent crime funds to apply towards the additional bills that they incurred. I can't accept both applications for the same incident. I hope that makes sense. So I've already talked about it. When a vehicle's involved, we need the charges. Now, they don't have to be convicted, but we need charges for DUI, OWI, DWI. We just need driving under the influence of either drugs or alcohol. In the case of a hit and run, because we actually just had one this morning, if it's a hit and run, by definition, the driver of the other vehicle, if the driver of the other vehicle is not caught within 24 hours, they cannot be tested. So these charges would not exist. So in the case when that happens, like the one this morning, we have to let the family know that according to our statutes, the crime does not rise to the level of a violent crime. It is a traffic accident, unfortunately, according to our statutes, and we cannot continue to process their application. Not always happy about that, but it does happen. And of course, the Good Samaritan laws would cover anyone who gets involved to try to help another and they're injured. We would definitely assist them with the payment of their medical bills resulting from that incident. Who is not eligible? Persons injured, if the crime does not occur in Indiana, we would have to refer that victim or the victim's family to the compensation program in the state where the crime occurred. If a victim is incarcerated at the time and they're physically assaulted, or if they're sexually assaulted while being detained, we cannot, according to our statutes, this is where all this is coming from, we cannot accept their application. And then what we're asking the police for is if, as a result of their investigation, and their investigation does not have to be complete, if they feel our victim, for example, if we get an application from someone who was injured in a bar fight, and we get information from law enforcement that says that that individual went in the bar and started the fight, we have to deny their claim for contributory misconduct. Or commonly we'll get information from law enforcement that says this was a drug deal gone bad. The individual who applied to our office was either selling the drugs, or they agreed to go and meet this individual to buy the drugs and were injured or killed as a result. With that evidence from law enforcement of illegal activity going on, we would deny those claims as well. And then we have that statute that says they have to have out-of-pocket medical expenses of more than $100. Unfortunately, we do have to enforce that. But like I said, even if the bill has been paid by their private insurance, they just need to submit it to our office to satisfy that requirement, and then we can continue processing their application. Okay, so we have a maximum on the violent crime side of $15,000 that we can apply towards someone's medical bills, dental bills, anything you see listed there on the screen. Every application that we approve is automatically eligible for our $3,000 counseling benefit. I can tell you that that is one of our least utilized benefits. Not sure why, even in the case of sexual assaults, not a lot of people asking for counseling. The funds are there. And if they receive counseling from a licensed provider, they can submit those bills to us. We can pay for them, or we can reimburse them if they haven't been paid yet. So that benefit is $3,000 maximum, or 2 years from the date of the crime, whichever comes first. That victim can. So if someone's already got an application with us and that we approved last year, they still have another year to start counseling and get us those bills. Lost wages comes up with, as you can probably imagine, with pretty much almost every application that we receive. Lost wages is a little different, and I'm not, the statement I'm making, it might sound funny to some, but you have to have a job originally, or you have to have a job to lose wages. And so that comes up a lot in our office. Another instance or situation that comes up a lot is those who are employed through a temp agency. Since that work is not guaranteed every day, it's hard to gauge what they lost. And so usually temp agencies do not qualify. However, we know in some cases, like with substitute teachers, there are individuals working on a contract. We can honor that contract and pay lost wages. The only issue that I would add is that the lost wages comes out of the same $15,000 pot. $15,000 max. The only benefit that is not included in that $15,000 is our funeral benefit, a reimbursement of $5,000. So I can have an individual, we can apply, they were injured and they pass away in the hospital a few days later. The family is left with medical bills from the 2 or 3 days they were in the emergency room. We can apply the $15,000 towards those medical bills, and then also reimburse for up to $5,000 for the cost of the funeral. The only thing, again, I would point out with the funeral costs is that we do not send that money to the individual that signs the application. That is a common belief. Once we do our investigation, once law enforcement informs us this was an innocent victim of a crime, there was no evidence of contributory misconduct or illegal activity, then we're going to contact the funeral home, or if they've already submitted bills and receipts, we're going to review that at that time and determine who it was that actually paid for the funeral, and that's who will get the $5,000. If multiple people paid, then multiple people will split the $5,000, but we do not reimburse for donations or GoFundMe accounts when we receive information that that's where the funds came from. Okay. Hope that makes sense. But we explain that, unfortunately, on a daily basis. One couple benefits that were added to our program a few years ago is crime scene cleanup. And that actually can be a lot more expensive than I realized until we started paying for them. But we are receiving bills now. If the crime occurs in someone's apartment or in someone's home, and a licensed crime scene cleanup provider is contacted, those bills can come to us and we can reimburse for those costs as well. If the crime scene is a vehicle, the same thing applies. We can reimburse for those costs. Now, Our VOCA grant does not allow us to replace property, but it does say that we can replace door locks and windows. So if the windows in the car were shot out and our victim has to replace the windows in their car, we can reimburse those. We can reimburse for those. The payment distribution is, as I said earlier, we do have to pay. We are required to pay the providers first, if at all possible. There are times when we simply cannot. If we pay the providers and there's $15,000 in bills that go out, unfortunately, that means that there is no funds left for the other benefits other than the funeral costs. Unfortunately, they say we have to pay the providers first. We cannot offer moving expenses, and relocation is probably the number one benefit that we get asked about that we unfortunately do not provide. And with the burial, there are some specifics about us paying for clothing, flowers, food we cannot pay for, but basically on a funeral bill, there's typically never food included, and the rest of it is one of the reasons we're capped at 5,000. That way I don't have to worry about someone submitting a bill for a $15,000 funeral. We're capped at 5. And so I don't have to review the bill as far as if there's flowers included on it. There usually is not on the funeral bill, but there's usually a separate charge for that. But the rest of pain and suffering is probably another issue that we get asked about on a daily basis. And unfortunately, our program does not allow us to pay for pain and suffering. The number one reason that we would deny a claim is the lack of cooperation with our division. All that simply is saying is we received an application, we send a letter requesting information, basically requesting medical bills related to the crime and any other receipts or anything else that our victim or claimant would like for us to consider paying. When we don't get a response to those letters, we cannot leave the claims open indefinitely, so we have to deny the claim for lack of cooperation with the division. When that occurs, I can give the victim the full 2 years that they had to apply from the date of the crime to get us the missing information, and if that's the only reason I denied the claim, I will be glad to reopen it. Many times we find out that our victim has simply moved and did not leave a forwarding address. And we definitely understand, given the situation, we understand when that happens. So we will deny the claim. But if we hear back from them within that 2-year time frame and they give us the bills that we were looking for, I am more than happy to reopen the claim and continue processing it. When I have to deny a claim for the other 3 reasons, typically we're going to go to a administrative hearing. It's a hearing in front of a judge. It is the right of every victim who applies to our office. When I deny a claim for any reason, they do have a right to an appeal. It is in writing in our statutes. So what happens is that we receive that writing. We receive a request for an appeal in writing. I forward that to our legal department. They will review the claim. If it's something that they feel we should have paid originally, then we can reopen the claim and just continue processing without having to go in front of a judge. But if they feel strongly that the information we got from law enforcement says that illegal activity was going on, then the victim or claimant has the right to sit in front of a judge and make their case to the judge, and we abide by their ruling. We just talked about that written process. We just need to get that in writing. We can't have one of our victims or claimants calling us over the phone and requesting an appeal over the phone. We just always direct them to follow whenever they get a denial letter from us for any reason. We will give them the statute that we're using as a basis for our denial, and then they can respond in writing. But an email sent to my office is just fine. But we just have to have that request in writing, and the hearing will be granted. We always like to point out that if someone is, as I did mention this earlier, if someone is injured as a result of a violent crime in another country, there are funds available to them, especially if, like in the case of Mexico, if that country does not have a victims compensation program, then you can come home. Typically, you can come home to the state. I think the only state that you can't do this in is Texas. but you can come home to your home state and apply there if a crime occurs in Mexico. Now, I can tell you countries like Germany, France, Italy, they actually have very good victims compensation programs where there's a lot of resources for people who are injured as a result of a violent crime in those countries. And in anyone who is injured abroad as a result of terrorism, there are funds available. Those funds are typically with that organization listed, and they're at I believe they're in the Department of Justice. But I just like to point out that there are funds available to help those who are injured as a result of crimes um, around in other countries. Are there any questions at all over the Violent Crime Fund?
First question is there any particular resources for inmates that are victims of STOP?
When someone is incarcerated, now this, from my understanding, their resources are tied to the agency who is holding them. They, by statutes, for whatever reason, it is written into our statutes that we cannot assist them. So if they're being held by DLC, then the resources they receive will probably have to come from DLC. I can't explain why that is, but when they set up our fund around 1978, that's just the way it was written.
So even if it's sheriff's department, that same policy is what we have to go by because DLC is different from us.
Yes, if an individual is being held by a county sheriff and they are injured or sexually assaulted while being held, the resources would have to come from the county sheriff. Unfortunately, they cannot apply to our program and receive help from us. And that is even on the sexual assault side, where if they go in, it occurs while they're being held at a county lockup and they go to a medical provider and receive a forensic exam. We have to reject those applications on the sexual assault side as well. According to our statutes, we cannot accept the application from them.
Yeah, because we have some of the inmates that were assaulted prior to being incarcerated.
Now, if they were assaulted prior to being incarcerated,
Yeah.
there's a chance they can still apply to our office. It just depends on the circumstances and where the crime occurred. Just in the scenario that you gave me, there is a possibility that we could help them, but not if they were assaulted in prison or in the jail. I hope that makes sense.
And we had another question. How much do the compensation eligibility/rules change between states?
Yeah, that's a good question. They change drastically. There are states that offer a lot more benefits to victims than we do. I would say Indiana is probably a little bit below the national average at offering $15,000 max. As you can probably imagine, a state like California has $1,000 max per application. They offer relocation and housing. There's other states that offer a lot more programs. So an individual who they may benefit, if you will, unfortunately, the situation they're in is not desirable, but they may benefit if the crime occurred in a different state that offered more programs or more help to them than Indiana does. But yes, they are very different. The eligibility is different. In many states, not every state has a requirement that you cooperate with law enforcement, especially in the cases of domestic violence. Many states are starting to waive that requirement and help the victims. It's just unfortunately in Indiana, there's no movement to waive that right or that, I'm sorry, waive that requirement right now at this time. So it is very different in different states.
And it looks like we have a follow-up question as well. Are there federal requirements that have to be met? For example, is the mental health counseling reimbursement happening in every state?
Well, again, it just depends on the state. It depends on society. For example, in different groups, different races, counseling is more widespread than others. We've noticed in what we do that, even cooperation with law enforcement is different with different groups. But in general, with the counseling benefit, even when it's a sexual assault of a minor child, for whatever reason, they just don't ask for a lot of counseling in Indiana. it's there, and everybody we come in contact with, we make sure that they know it's there for them, but it's not, yeah, it's not a benefit that we're asked about very often. One thing I will add to this, if someone relocates, if they're injured as a result of a crime, even domestic violence, they're cooperating with law enforcement and everything else is fine, but they move to another state, but they still want counseling, they can go in whatever state they're in and receive counseling from a licensed counselor with that state. So that they don't have to be licensed in Indiana, and they can still submit the bills to us in Indiana, and we can still pay them if the crime occurred here. And we recently paid for an individual's counseling, and she had moved to Utah. She had a state provider providing counseling for her, and we had no trouble reimbursing her for the counseling costs. But it's like I said, it is rare. I hope that answered your question. What do you mean by federal requirements?
Caitlin, would you like to come off of mute and
Yeah, I can
give us a little
definitely do that. Sorry. I'm just trying to get an understanding if, like, with this funding, if there are federal requirements that have to be met in every state, like, besides just the basic victims' compensation.
Oh,
Are
okay.
there,
Okay. I think I understand where you're coming from. Yes, every state receives their grants from the same office. For the VOCA grant comes from the Department of Justice. Okay. They have the Department of Justice has a very basic um set of rules governing what you can and can't do with the money they pass out. It's the individual states and that state's legislature that determine how they spend the money in their state. So at the federal level, you will find that they're actually, at the federal level, for example, there is no requirement that a victim cooperates with law enforcement, but many states have that requirement. In Texas, and I did mention Texas. So if anyone's from Texas, don't be offended. I'm not mad at you. But Texas legislature has passed a rule that even if you are in Texas on vacation and you are the victim of a crime, if you are not a resident of Texas, you cannot apply for their victims compensation fund. They're the only state that has done that. But again, there's nothing in the federal regulations that say they can't do that. So usually if we get a victim who is visiting Texas from Indiana and they're the victim of a crime, we already know that when they come back to Indiana, they're going to be applying here. They have to apply here if they want assistance because they cannot apply in Texas. It's controlled by the individual states.
okay, thank you so much.
Mhm.
That makes a lot more sense.
Okay.
So you were mentioning about Germany, European nations, and all of that. So my question is, if you're a resident of Indiana and you went to Africa and you're a victim of sexual assault or vocal or stop, when you return to the US, are you qualified to come to you or your agency to apply for these things?
Again, the best general answer I could give is probably yes, but each state is going to be different on how they handle it. For one, I would assume that most of the countries, since you specifically said Africa, will not have a victims compensation program. So it depends on the state. I can tell you, being in Indiana, if I was presented with that scenario, when you came back, I would accept your application and pay for your forensic exam, if that
Thank you.
helps.
Thank
Okay.
you. That makes sense.
And if there's no other questions, I'll be glad to go right into the second application. We can use that question and go right into talking about sexual assaults. Now, it won't take as long. I can tell you up front, the individuals applying for sexual assault reimbursement are the hospitals. The victim or the victim's family member, if the victim is a minor, they can't sign our sexual assault application, of course, but the victim's family can sign it. They will sign the application, but the properly submitted claim for reimbursement is going to come from the provider that performs the forensic exam. So it's seldom that we will hear from or talk to a victim of a sexual assault. because the hospital is going to apply. The hospital knows that anything related to the forensic exam, they are not allowed by law in Indiana to charge the victim for. So they're going to send us the application, and we can talk more about, there are some times when we deny, but usually if we hear from a sexual assault victim, it's only for two reasons. And the most common reason is they want to find out information on their kit, which I can talk about more in a moment. But with the forensic exam, and I just have a copy of the Indiana Code governing our forensic program. I've given these presentations to hospital and service providers before, and that's usually why I include this information. They are required to perform. Now, where the issues might come in for a victim is if other services are provided to the victim in addition to the forensic exam. If that individual has extensive injuries or a hospital stay was involved, or they had to get a room to recover from their injuries, I can still only pay for the forensic exam from the sexual assault fund. But as I said in the beginning, I can accept a violent crime application from that individual for the same incident. And because they changed our laws around this area a few years ago, they do not have to cooperate with law enforcement if they got the forensic exam. We can take the forensic exam as proof of reporting and cooperating with law enforcement. And so that allows us to just apply the additional $15,000 to whatever other medical bills they have. But this is just a brief list, and I'm sure you can imagine there's probably more to add to this list. But basically, especially when it comes to a minor, pretty much everything would apply. Any crime that you can pretty much think of, we can accept the application for. And again, the hospitals know this, but they would all qualify. Direct allocations, this is just where the money comes from. I just point out that with this sexual assault program, we are using state funds. So we are not using VOCA funds for our state program. So there's certain rules that wouldn't apply to us. But basically, and I can tell you with that said, Indiana pays more in sexual assault forensic examination funding than any other state in the country. We have a statute that reads part of our statute reads other additional services. So if that individual in Indiana receives a forensic exam, but in the narrative that we're supposed to get, if there's information in there that this individual was physically assaulted if there was a violent physical attack, we understand the need for the CAT scan, the x-rays, the MRIs, and we can include all of that under the sexual assault reimbursement to the providers so that the victims do not get those bills. Not every state does that. Very few states actually will do the additional related services. So that is a plus for Indiana. We can catch a lot of the expenses so that the individual does not get charged for this. This is it's just the front page of our application. Again, there's a place for the victim or the victim's guardian, parents or guardians to sign at the top, but the rest of the information is completed by the provider. One thing we do have to point out, we do see it commonly in our office, is a minor, legal minor in Indiana for us is 17 years of age or younger. At 17 years of age or younger, they cannot give permission for sex. So even if a 17-year-old goes in and, she's arguing with her mother that she wasn't raped, we get this a lot. She was in relationship with the gentleman who may have been 18. We can still accept that application because she was 17 and not able to give legal permission. We can accept the application, pay for all the expenses related to the gathering of evidence, but the mother or the parent would have to sign that application. There are times when, we see it a lot around university towns where the minor child, 16 or 17 years of age, doesn't want their parents to know Unfortunately, a parent has to know in order for us to reimburse. The parent has to, and actually, law enforcement has to be notified. 17 years of age or younger, law enforcement, and we do consider DCS to be law enforcement. So as long as DCS is involved, we can accept that application and pay for all those expenses. But that's only with 17 years of age or younger. For adult victims, as I'm sure most of you know, you do not have to report to law enforcement to receive a forensic exam and have us reimburse for the expenses related to that exam. This is just an explanation for the service providers we talked to. And basically, this is a list of all the services related to a forensic exam. It's just normal services that you would consider part, and we consider part of a forensic exam that we can pay for. And as of 2017, the 30-day prophylactic treatment after a sexual assault, we can pay for. That change was made in 2017, I believe. So what is typically happening, I can tell you what happened in the very beginning when we started paying for these. They were giving a script to the victims, and they were going to a pharmacy to have the script filled. The drugs at the time were about $3,000, and some of our victims had to come out of pocket if they wanted those drugs. Now, today, the hospitals or service providers who are dispensing these drugs typically are giving the drugs to the victims in the emergency rooms and then billing us, which is fine with us. The front cover of our applications, our sexual assault applications, have a voucher on the front of it, and they will tear off that voucher in the emergency room and hand that to the victim, and with some other additional information. But the victims can take that voucher to a pharmacy, and the pharmacist will give them the drugs, accept that voucher, because they know that they can bill us. As long as the victims are not getting billed, we're fine with either method. Because like I said, in the beginning, when we first started doing this, the victims had to come out of pocket. And the price of those drugs today are 3 times as much. So we don't want that to happen. So yeah, we get those bills either directly from the pharmacist, or we get it directly from the service provider, included with their itemized hospital bill they send us. Okay. The victims are also, according to our program, or the statutes governing us, they're entitled to 2 follow-up visits after the initial forensic exam. The first is 30 days. Now, we don't necessarily hold them to the timeline. Just know, or you can just let them know, that they are entitled to 2 follow-up visits. STD testing and pregnancy testing after 30 days, more or less. And then after 90 days, they can go back for more STD testing, but specifically syphilis testing is what our statutes, or how our statutes read. Okay, 2 follow-up visits, and we will cover the expenses for those visits, the emergency room charge, and for the testing that happens. And then again, every application for a sexual assault, now I would say that we approve, because we're required to by law, we probably approve 97% of every application sent in to us. So these are all victims who, once we accept the application and approve it, they're all eligible for counseling. Again, it's just not a request that we get very often. We try to spread that word as much as we can, that they can get the counseling if they would like. And I will say, with the sexual assault fund, there is no cap. So no matter how much the hospital charges us for the reimbursement for the forensic exam, they still have $3,000 in counseling that they could take advantage of if they like. Now, this is, like I said, we approve the majority of the sexual assault applications that we receive, but there are some requirements. We deny a handful because the hospitals have 180 days from the date of the forensic exam to get us a properly submitted claim. Now, with that, and it does happen where hospitals simply wait more than 6 months before they get us the application. They cannot turn around when we deny for this reason, they cannot turn around and bill the victims. They are still prevented from doing that. They cannot bill the victims for something they got wrong. It doesn't happen often, but it does happen, unfortunately. And we just have to point out sometimes the billing offices, and you may want to share this with, if you run across this, sometimes the billing offices are not aware that the services provided were for a forensic exam. And, if coding was not done correctly in the hospital, which we are told happens from time to time. Once it is made clear to the billing office that these services provided were for a forensic exam, they have to stop all collection actions towards that victim. They are not allowed to charge that victim, and they definitely cannot charge them for a mistake that they made. So they have 180 days to get us the application. They do not have an appeal process. What happens is, as you can probably imagine, they don't like to send one application in the mail when they get it. A lot of hospitals will hold their applications coming to us to the end of the month and send us a couple dozen at a time, or however many they had for that month. It's just that, unfortunately, for whatever reason, some will wait 6 months before we get the application. And at that point, we can't pay. With the sexual assault program, we are required by law to pay those bills. So in this case, the victim's insurance would not matter. The bills can come to us. If a victim happens to get a bill in the mail and it was from a forensic exam, I'm sure, believe me, it was a mistake. But if they get it in the mail, they can easily just turn around and mail it directly to us. As long as we have an application to match it up with, we'll take it from them and pay it right away. It's not a problem. So I do want to mention that the second reason that we would hear from victims of sexual assault, I should say the main reason we would hear from them, is they want to track the status of where their kid is. Our SAKI system, our kit tracking system, again, is part of the same claims management system. It is down currently. We are desperately trying to get we have a new vendor selected. We are appropriating the money to pay for it, and we're hoping to have our new claim system up and running within the next several months. The SAKI system will be back up at that time. But until then, they can contact us directly. If they have their kit number and the PIN number with that kit, they can give us a call. If they don't have the PIN number, they can still call us. We're doing it over the phone for them. So either myself or my staff can take their information. We'll look into our system. And as long as their kit is in there, and they give us whatever information that we need to help identify them as the victim, then we can give them a kit number and we can tell them where their kit is. We're doing that over the phone right now because, our system, that online portal, is down and it's not coming back up. So I didn't want to throw that out there. But as far as denials of sexual assaults, usually it's either 180 days or, in some cases with an adult victim, a forensic exam is given more than 5 days after exposure. And according to the CDC's guidelines, you're not gathering evidence if you perform a forensic exam more than 5 days after the incident. And so we would deny for that reason. I think locally in Indiana, most providers go by a 96-hour window. Some said it's 84. All we're saying is, since the CDC says 120 hours, we give you the max. But if you perform a forensic exam after that, then we can't reimburse for that. Usually, we don't have any instances of a hospital trying to turn around and charge the victim when we deny for that reason. But again, that would get into an area of the law that I'm not that familiar with. I can just tell you from personal experience, and I've done this for about 14 years now. I've not heard of we deny for that reason. I've not heard of a hospital going after the victim. They usually would just write it off as charity. And then the other thing that we've already talked about, if the victim is incarcerated at the time, we cannot accept their sexual assault application, unfortunately. As advocates, when we first started this, when we first started this session, the number one thing you can do for us is help to spread correct information. And if it's something that you're not aware of, please encourage the victims to call us directly. We hear all the time misinformation that is given to them. More times than not, especially on the violent crime side, it's from someone who is claiming that they've already filed an application in our office and we denied theirs. So they tell their friend or loved one that we will deny their claim as well. But they don't usually give the details as far as exactly why we denied their claim, if we denied it at all. We just strongly encourage you to give them the information. You can help them fill out the applications. Please stress to them that all the information on there is important, including the narrative, as much as they, and this is with the violent crime applications, as much as they understand what was told to them occurred, if they can put that in the narrative for us, that will help us and when we're trying to gather information. Okay, but you can definitely assist them. You cannot sign it. Now, one thing you can do is if you want to help the victim by following up on their application in our office, we will be glad to talk to you. But please point out to the victim that they need to give us that information in writing. If they like, they can just do a little handwritten note and submit it with their application that this is my victim's advocate, this is her name, or this is their name, and they have my permission to check on my claim for me. We will put that in the file with their application, and then you can call whenever you like to check on their behalf to see where we are with their claim. I will say you already have asked some very, very good questions. I really enjoy talking to you. Can't think of what happened, but I can't apologize enough for that. Hopefully I've made up for it. And you will have a copy of this presentation with all of our contact information in it. Our website is simply, if we're a state agency, so our website is www.in.gov/CJI. And if you go to our website, other than finding our violent crime application, you will also see more information about our agency and programs and all the other wonderful things that our agency does will be shown.
I have
Will be
a
shown.
question,
Yes, ma'am.
and my question is, the male population,
Mhm.
do they benefit the same thing as the female population, or it's gender based?
No. They are welcome to whatever benefits they can apply. We know more and more. It's 2025, so we're seeing sexual assault victims of all ages and all genders. We can accept their application. We would not process any of them any differently than the next. Thank you guys for your time. I really do appreciate it. Great questions, and thank you all for what you do for the victims in Indiana. Thank you guys very much.